Hey there, this is James Adair with Keller Williams, and I am hosting today an amazing conversation with Candice, who is an attorney who handles insurance and disaster type claims. Candice, tell them just a little bit about yourself.
So thank you so much for having me. So I am attorney Candice Colucci and I own Colucci Law Group. So our law firm specializes in property insurance claims and specifically specializes in hurricane law. So we represent a property owner against their insurance company in order for them to be fully paid for their losses and damages in accordance with their insurance policy.
Sweet. And now what we're going to do is join one of our previous conversations to answer some of the top 10 questions that insurance folks have, and we'll see you on the other side. So the reason why I have connected with Candice and her practice is that through my gleaning and interviewing process of different firms and people I personally worked with before, she had the most to offer. She knew what the heck she was talking about. And she had the chutzpah to get it done. So, a lot of times attorneys need to get their own bills paid first, and they have the desperation of closing. That's not her, and so that's why I felt like she had the expertise and knowledge. That's why I wanted to bring her on for this. So we have a rapid fire set of questions. We're going to go through them. If you want to sit through the whole video, that's great. If not, we'll have separate breakouts that you'll be able to just focus in as well. So tell us a little bit about the process. A storm happens. What is the normal process an insured goes through?
So after you have that damage, the next thing that usually happens is you're going to call in your claim. So that is huge. So there's still people who 2 months later haven't called in their claim. So I always say, even if you're not sure the extent of damage, you call in your claim. Then you need to take your own documentation take your own photos, your own video, make sure you're not doing any permanent repairs yet until the insurance company comes out. Then the insurance company will come out and they'll do an inspection of your property. So they have 90 days from the date of loss in order to make a coverage decision and pay that claim. So they have 90 days. So they'll come out and do an inspection. Then they will produce to you usually an estimate of what they believe is the valuation of the damages. Then after that, usually the insured gets that check and that estimate. And a lot of times they realize then that they are potentially not being paid enough in order to get their house fixed. They usually find that out from contractors. And then that's usually at that point where they start going, okay, now what do I do? I don't have enough money. And now where do I go from there?
Dead on. Yeah. So I had my own claim once, verbatim, exactly that same play. All right. So let's say you're not the best neighbor. Let's say you're not their best friend and they somehow are not who you bought the insurance from. You know, that beautiful State Farm or Geico agent that is wonderful on the phone. You have family picnics with them. They're out of the picture. You can't really talk to them anyway. You're talking to some 800 number and then you figure out, oh my gosh, this isn't going to go well. What's the usual tactics before somebody hires an attorney that the companies use? And then what are the tactics after they hire somebody like you?
So usually the tactics are very, very common with what the insurance company will do. So great. If there's one that pays you enough, fantastic. But unfortunately, the more common thing is you'll hear things like the insurance company will say things are not covered under your insurance policy when you would have thought potentially they were. And so that's one thing they'll usually say. Another thing is like, let's just say that you say, hey, that's not enough money. And you say, well, there's this, and this is how much they need. They're going to potentially attack the validity of the contractor's numbers. So they usually say, well, that contractor's overcharging you. It's not us. So that's something that they do a lot. And then the other thing they do a lot is they just don't respond. They'll just literally not respond.
They won't respond? What does that mean? They won't return your calls?
Yeah. Yes. Unfortunately, that is a very, very common, especially after a hurricane as big as the one that we're dealing with right now. There's just so many insurance claims that are being filed. And so on a normal situation, they have a hard time keeping up with it, or they just maybe potentially intentionally don't respond. But now after something as large as this, we're definitely seeing much more a lack of response.
Yeah, and that's happening right now. On the other side, we're hearing the clients go, I have submitted 9 times the same thing over and over again, and I've not heard back from this one, you know. All right, so once they hire you, right, and they step, the homeowner steps out, and they say, okay, take it. I can't handle this anymore. What's the normal playbook that they use that you have to go through?
Yeah. So after an insured has usually gotten their initial money from the insurance company, realized it was enough. I mean, realize it wasn't enough. Then they usually start trying to work the claim themselves, which if you think about it in comparison to a personal injury, into an accident right now, you already know, got to call a lawyer, right? You don't start calling the adjuster and figuring out, hey, so I think I have a spinal herniated disc. And I think the value of that herniated disc is this. And so they don't do that. But for some reason, because this industry and this area of law is much less common, people just think to work their claim themselves. So they'll start trying to make those calls themselves, talk to the insurance company, and then they find themselves potentially having to argue over damage. Oh, was your soffit and fascia damage? Like, is there anything wrong with your drip edge? Like those kind of things, like words that they had never really heard probably very often before. And then they usually get very exhausted, frustrated, and angry. And when they finally get to that, usually takes about it usually takes between 2 months of fighting. Some of them fight for 6 months. And then eventually they're just like at a loss, right? And that's usually when they'll reach out to us after they have to work it themselves, gave the insurance company the opportunity because they trusted them, right? They heard all those commercials. They have gotten the emails from their insurance company. So they have full trust that they're going to do what's right. Then when they realize that they're not, and they go through that disappointing time, they call our firm. And so what we do, and we do it all contingency. So if we don't get any additional money, you don't have any responsibility to pay us. We get involved and we do another inspection on your behalf. So we come out there, inspect the damages. We create an estimate that we believe is reflective of your damage. And then we fight back and forth with the insurance company to try to get them to come to an agreement and settle. The tactics that they use with us are a little bit different. They're definitely more in depth, and there's things that they would never even think about trying to say to us a lot of times because we're lawyers. We obviously know the law. When they usually try to get advantage of their clients by their lack of knowledge of the law. Pretty much for us, the most of the time they're doing is usually just delaying, like just trying to find ways to keep on asking for additional documents that aren't really needed. So they kind of drag their feet. And then a lot of times they do pay because they know that we can sue them. Like they don't believe a homeowner can do it by themselves. So we can file a lawsuit. So if we can settle it during pre-litigation, we do. We do that a lot. And then if they don't pay enough and the insured is in agreement with that, then we file a lawsuit. We do it all in one firm. Are going forward with litigation and we set it for a trial. That's the best way to do it. We do it right after we file a lawsuit, and then we just go back and forth with them until we can come to a settlement.
That's that nugget that she just dropped right there is super important. My case lasted a year, different attorney, and we waited too long to file it and ask for the trial. And once that got going, then all of a sudden magic started happening.
Yes. So, yep, exactly.
Yeah, that's vital. All right, cool. So you touched on a few of the super big items. One thing I wanted to just circle back around with, when a homeowner goes out alone, so I'm in the real estate space, and sometimes for sale by owners, they try and sell their house on their own, and sometimes you don't need an agent, I get that. Other times, people do themselves some harm. So in your side of things, what are the common pitfalls that the insured puts themselves at a disadvantage by maybe saying the wrong thing, offering the wrong information to the insurance company that then makes your job a little bit harder or doesn't serve them later? So what's that look like?
So I like to compare it to the reason why people say all the time, like, even if you're innocent, you should have an attorney with you and not speak to the police department. Like it's not the fact that you have anything to hide a lot of times. It's the fact that you may say things that end up getting misconstrued and twisted around and used against you later on. And as an attorney in this industry, I can tell you that happens a lot. When we get a file and the insured has insurance company and they may say something as innocent as, oh, I've got flooding in my house. So they use the word flood because water has now potentially all in their home. But the problem about the word flood is, though it seems like it's flooding, right? Because you've got water inside, unless the water had come from the ground up, an actual flood, then it's not flood in the eyes of what the insurance company sees. And if you've called your homeowner's insurance and you've said you think flooding, they will deny the claim and say, okay, well, we don't cover flood. You need to call your flood insurance. So that is a huge thing that gets used against them. The other thing is, there are types of damage that doesn't become visible until sometimes months later. So like the stains on your roof. So you may have a roof that's compromised. Water may have come through the roof. And now it's literally seeping through your decking and all of that stuff. And it's going through your insulation. And it sometimes can take it months for it to surface and show itself on the ceiling. So a lot of homeowners, unfortunately, will tell the insurance company, I don't have any damage inside. The water didn't come into my house. Like they'll just say that point blank just because they don't see any stains yet. And then months later, when they start to actually get water stains, the insurance company can use it against them by saying, well, you told us you didn't have damage. Now we believe this damage came from something else, not from the hurricane. So those are just some of the common things that are usually where they're being said innocently, but the insurance is using it against them. Or they may look at their roof and go, I don't think my roof's damaged, just because they don't see missing shingles or missing tile pieces, but it could potentially be compromised. So if you didn't have an expert go up there and look at an expert that works for you, then you may potentially lose out on an entire claim. So those are just some of the common things that we see a lot when the insureds try to work it themselves and can potentially harm themselves.
Yeah, and what's the story with mold? I heard and it's funny when you're talking and there's gossip and people and things, you don't know what to rely on or not. But there was this interesting conversation about mold in the home, and if you call and say, "Hey, we're taking a mold," it goes under some mold rider, which may cap the expense at like $10,000. But if you were on the beach and it sat for 2 weeks, I mean, I would assume are there any of those kind of things that people didn't know?
Yes, for sure. So almost every policy will always have mold limitation, and majority of the homeowners policy, especially in Florida, their mold limitation is $10,000. So no matter what, no matter which way it came from, you're going to have only $10,000 that goes to mold remediation. So the reason why we tell people to be really cautious about not saying that, because there is a difference between water mitigation and mold mitigation, but they can potentially overlap. So what you want to make sure is that the insurance company will try to say, okay, well, all of these walls were damaged and behind the walls, or you potentially have mold that's coming through the ceiling. And so you're going to say, well, I have to do a mold mitigation, and you'll take all of that out. You've got to do air scrubbers to clean the air and all of those things. And the insurance company will say, well, all that's mold. So, and let's say that your invoice is $25,000. Well, if you're working with an expert, like an attorney or a public adjuster, those people know how to potentially actually state it to the insurance company, when you should have said, because of the water damage, we had to take off the walls. And the only thing we did for mold was the air scrubbers. It wasn't actually to remove the drywall and the floor and those kind of things. Even though they have mold on them, they're being removed because they actually had contaminated water that came in through your ceiling. So it's just one of those things that, like, the reason why they say be careful saying mold to the insurance company and then acting like all of that remediation was really for mold, when really part of it's for water and part of it's for mold. Usually allows you to stay underneath that mold cap. In a regular residential home, you can usually do a mold mitigation if you use the right company for $10,000, a normal sized home. So because you're packaging it with the water mitigation, it needs to be done.
Got it. So question, when most of the recent event, we've already passed all of what we're about to ask about, but a new storm hits, your house is flooded, roofs, whatever. And you're deciding, do I take all of my goodies and throw them out on the street and then take 4 foot of drywall out and put it out? Like, when a person's asking that question, do I let my house barf out on the street? Like, what do they need to answer with that? Because I mean, most of these people that will see this video now are already past that. Everything they own is already on the street. Got it. But for future, what do you do?
So let's start with what's in almost every single insurance policy, is that you probably didn't realize that there's a policy, and it actually states that you are going to show the damaged property to the insurance company when they reasonably ask for it. So what that means, that's an agreement. There's an agreement between you and the insurance company. You've agreed that you're going to do all these things, and they've agreed that they're going to pay. So one of the agreements that you don't know you make is that you're going to show them the damaged property. They have a right to see it. And if you impede that right to see the damaged property, they can turn and potentially deny your claim or deny that part of the coverage.
So wait,
So
they want to see it in person, or will pictures work?
see it in person. They have the right to see it in person. Yeah.
Oh,
Yeah.
that's so dirty.
Yeah, absolutely. So here's how we normally deal with those situations is that let's say that you do want to get, and we were trying to, make sure everybody understood this and educate them the best that we could, is that if you're going to get rid of the content in your property, so a lot of people want to, right? They're damaged, they're wet, starting to become moldy. There's several things you have to do. One is you have to take pictures of them. You have to take video of it. You have to make sure you itemize every single item that you're getting rid of. But the very most important part is you have to let the insurance company know and give them an opportunity to inspect it. So the way that we do that is we tell them, you send an email to the insurance company and you tell them that we have damaged content. We're going to itemize it. We're going to take photos of it, but we need to get rid of the house so it doesn't create more damage. If we do not hear from you within the next 4 days, we will assume that you don't want to see the property. So then we can go ahead and get rid of it. So you want to at least give them a time period, or at least if you decide you don't want to do that and you're going to get rid of it today, still give them an email letting them know that you put it out on the front of your property, the corner of your property, right? That it's literally on the street, because we're seeing it. We're driving around. We see most people's entire houses, you said, had thrown up on their curb. So you can also say it's on the curb, like it's here. You're more than welcome to come and see it. Because you would be surprised, and it's sad. The insurance companies go from being your friend to being literally your enemy, and they will try to find any way to get out of actually paying the claim. So one of the things that they'll do, and I have dealt with this so many times, is now they're fighting and we're in litigation, we're in a lawsuit, and they're sitting the insured down for a deposition, and insureds have this whole content list, right? Like they've got $100,000 worth of content sometimes. And the insurance company's like, well, where are they? And what happened to them? And they're like, well, I threw them away. Like, well, when did you throw them away? You never let us know. Remember, they have an obligation to show it to you, and they can literally try to deny covering it because you didn't actually give them the opportunity to see it. So that's worst case scenario. Do they do it all the time? No. But do you want to take that risk? No. So it's better protecting yourself, making sure you've inventoried it right, but you've let the insurance company know that you're intending to get rid of it, or that you're about to get rid of it, or where it's at if they want to go find it.
That's worth gold right there. I mean,
I know,
if
it's
you're watching
crazy.
this video and you got a storm coming and I tell you to come watch this video later, this is what you want to watch. I always tell everybody, take your pictures before all the blah, blah, blah. But
Yes.
that is gold right there, because, I took my pictures, but if you don't tell them that it's at the curb, go take a look.
Yeah.
Wow. That's nuts. All right, perfect. Okay, so here's a dumb question. Who actually reads their policy, the full jet?
I have never really met anyone who's read an entire policy from beginning to end unless they're a lawyer. I mean, it's just, I don't even think that the insurance companies read them. I don't think agents read them, love them, but agents read them, no property owner. And I will be very honest, before I became an insurance attorney, I had never read an entire policy. Like, that was literally probably one of the very first things I did when I got into this industry. I was like, didn't even know that my agent only ever gave me 5 pages of the policy, that there really was 80 pages. Never knew that ever. So it was definitely an eye-opening experience for me. So it's completely normal. Nobody reads them. Most people don't even ever receive a full policy until you go through something like this, a disaster company, and they usually find out that there's hidden exclusions in there. So that's usually when they start realizing, oh gosh, I even have more than 4 pages of a policy. So pretty much nobody does.
Yeah.
Besides us lawyers.
It blew my mind when I realized that the person selling me the policy had never read it. Blew my mind that the person who's adjusting my policy had never read it. It blew me away. Are you kidding? This is what I thought you people. Anyway, so homeowners, don't be sad if you hadn't read it. I'm sure you get real motivated after you get denied. You'll go and read everything. And the problem is, and I'm sure, Candice, you'll agree, sometimes there's even conflicting language inside of it that doesn't even agree with other parts of the policy. One part will overwrite the other part, and you don't know which one to believe. And then during litigation, they'll argue both points. It wasn't it wasn't a hurricane, but yet I have to pay a hurricane deductible. So which is it?
Yeah.
All right. That was a mind blow. All right. So let's just say you're back early in this process. How do you know as a homeowner that you're about to get screwed? Like, what are those triggers? You've seen enough of this now, not just in the law side, but roofs and all the vendors. What's the triggers that these people should look for I'm about to get screwed? Because right now nobody trusts anybody down there.
Yeah. I would tell people to list, like, there's such a level of that's intuition. It's going to feel wrong. Right. And I'll say, I usually go, as soon as they start saying no, or just not answering after you've asked for some follow-ups, those are usually the points there where you go, okay, I'm definitely about to get screwed over. I'm getting screwed over. So it's usually pretty obvious. And I tell people, question everything. If it sounds good because you're getting everything you need covered, then great. But as soon as you're not getting everything you need and there's excuses, whether you think they're valid or not, if the answer is not that you're getting everything that you feel like you need, then that's when you should know. And that's when you can always reach out to an attorney who will do a free consultation, look over your files and what you've been paid so far. A lot of us do free inspections. So our firm does a free inspection. So we can go and look at the property and give you a comparison. And I won't say it's never happened, but it's very rare for the fact going out there and saying, hey, no, the insurance company did pay you enough, or saying, hey, this exclusion that they've relied upon is actually a valid exclusion. So you can get that free consultation, but really it's about just kind of trusting your instincts. And it's almost like black and white. It's like, if you needed $30,000 for a roof and they paid you 10 and they're telling you not going to pay you 30, like, and you need the 30, then that should be your trigger. You're like, okay, well, they're saying they're not going to pay it. I feel like I need it. This contractor said that so maybe I need to go see a specialist, like an attorney, to have them review it to see if I'm not being treated fairly.
So would that be called a policy review? Is that right?
Yeah. So that would be like a free consultation. And in our industry, the consultation would be a policy review and usually an inspection.
And that's when probably the eyes get open and they're like, oh my gosh,
Yep.
I didn't realize.
Absolutely.
I had gold in my house. The gold's gone. That's not covered, but all of my other contents are. Things like that you'd never think about.
Yes, exactly.
All right, very good. Okay, so let's just say you had a house, you're paying your mortgage, then you don't have a house anymore, you're paying rent. Under the policy, what does it speak to about that kind of payments and all of that stuff? I hear it's getting very muddy right now.
So most homeowners policy will have a coverage, usually D, and that coverage is considered additional living expenses. People will call it AO. And so that is your additional cost of living that is directly the result of the covered loss. So like the hurricane, that is in addition to what your normal expenses were. So that's kind of where people get really kind of tricky about it, is that if the month before the hurricane, you were spending X amount of dollars on groceries, and now after the hurricane, your home destroyed and you're living in a hotel and you're buying food out all the time, what they're going to cover is the additional expenses for food. So it would be like whatever your normal expenses were minus what now you're spending, and it'd be that number. It's not all of it. It's the additional amount of money. So that, and usually takes its form of you're living in a hotel, right? Or you had to get an apartment, now you have another rent. Those usually things, as long as you're still having to pay home, now that becomes all additional electricity, internet, like anything that's double now. If you still have it at your home and now you have it where you're staying now. And then also people don't think about it, but if you now have to drive a further distance because of the fact that you're not at your home, like let's say you worked near your business where you lived, and now you've had to move because of how the housing has just been 45 minutes away, you can now be entitled that now you have to spend. So it's those kind of things. That question is, what is additional because of the hurricane? And that's usually what they will cover. Now, this is another issue that we always have a lot, is that most policies require that the insured incurs the cost first.
Yeah.
So which means you have to pay for it and then the insurance company reimburses you. So
That's so.
As you can imagine, that's hard for
Yes,
most people.
I want to attack that for a second. That's so good.
Yeah.
Is all of this called or a part of loss of use, or is that a whole
Yes,
different?
loss of use. Yeah, another word for it is loss of use. Yep.
Okay, all right. So let's dive into this piece real quick because when I went through my claim, I did not want to buy all of my appliances with the fear that this company was not going to reimburse me.
Absolutely.
That's why I lived out of that kegerator for an entire year.
Yeah.
So when you said that you actually have to incur the expense, what what's the caveat? What's the wisdom there? Because if you go out and re-rent something at $2,000 and you're driving and you now have groceries or whatever all that is, you're now out 10, 20 grand. Are there caps to this? Like, how do people get screwed over on that? I mean, that sounds super dicey.
So the caps are, your policy has a policy cap of how much you can spend. There's a certain amount of money, that number that's there. But there also is, in most policies, it will say that we're going to cover this loss of use, additional living expenses. A lot of times it'll cap it off time wise. Sometimes the amount of time that you reasonably should have been back into your house, or 2 years from the date of loss. So a lot of times there'll be a time cap while there is a money cap. And it makes it a risk. There's a lot of people who have spent money and then demanded the reimbursement from the insurance company, and the insurance company makes any type of reason. They may say the reason is we believe that we gave you enough money already, and therefore you should have fixed the property and been back into your house. So now we're not going to pay for it, even though you're demanding more money from us. We're telling you we're not paying it, and we believe you should have already moved back into your house. So that's one way that they'll try to deny the additional living expenses. Then the other way that they'll try to deny it is sometimes they'll say that the requirement is to put you in something kind of similar to the way you were living. So if you were living in a 2-bedroom home and you go and rent a 4-bedroom home, they can say, well, no, we're not going to pay for a 4-bedroom home because that's not similar to the way that you were living before. So those are things that they sometimes will stand behind and try to say that there's a denial. So then that alone, like, let's just say you have, this loss of use, additional living expenses for $5,000, and the insurance company doesn't pay it, but they paid you for the home in full. You can still hire a lawyer who can sue for just that portion of it, because technically it's part of your entire policy. And if the insurance company doesn't reimburse you, they've breached the contract, the policy.
Fascinating. And then before we move on to this next question, there's a loan called a 203H loan. And there's one piece of the 203H loan I had not figured out yet, and I think you might have just given me a clue to it. It allows somebody who has had a disaster impact like this. It had been previously used for COVID, but what it does is it says you could buy under FHA a home for 100% down. Okay, I'm sorry, 100%, no money down.
Yep.
Great situation as long as your first home is now unlivable. They won't count against you debt to income wise for the current residence, but
yeah,
they qualify you on the future one. So I'm now kind of curious. Would the insurance company have to, let's say it's an even Steven house, and the new mortgage is, I don't know, 2,000, and your old mortgage was 2,000. Would they pay that out, or would you still have to just make the same case that, hey, this is what I had to do. I went and bought a house, and this is my new mortgage payment?
They're just going to pay each monthly payment. Yeah. So they would reimburse you for the monthly payment, the $2,000 a month.
Okay. All right. Rent or otherwise.
Yep.
Okay. Wow. Well, that just fixed the problem for me. That's great.
Yeah. Because it's an additional expense. You wouldn't have needed it if your home was livable.
Yeah. Do you, I have another question that's related to the 203. What are people doing when they have these, houses they can't live in and they have these payments? Or have you gotten involved much with putting mortgages in deferment?
So I don't try not to get too involved much, but I do tell them they need to call the mortgage company and be honest about the situation. And a lot of times the mortgage companies will do like a disaster deferment. So I will say that usually they try to be as reasonable as possible. Also for the fact that they hate foreclosing on it when there's an insurance claim and all of those other pieces, but it does happen. Unfortunately, there are times, and people have to realize that if you are living in a home and you've had a disaster and you file an insurance claim and your home goes into foreclosure, your mortgage company is the one who's entitled to all the money from the policy that has to do with repairing the property. So that People don't realize that. I'm like, and not only they're entitled to it, their name gets put on the check and they get notified. And so they will come and get that check and make sure that it's not getting cashed without them actually taking it all.
All right, so let's do that as its own question. This is very interesting.
Okay.
Let's say they're sending out money and they have a mortgage, right? You have it insured. All of a sudden, they come out and they said, okay, it's a $10,000 roof. We'll give you $10,000 for the roof. What happens next? They have a check. Now what? They're going to Vegas?
Yeah, okay. That was a lot of people wish. So every mortgage company is slightly different, but what people don't realize is when you take out a mortgage and you sign all that paperwork, you are signing and agreeing to certain things. And one of the things you're usually agreeing to is that if at any point in time, there's a requirement to have an insurance policy when you have a mortgage, to protect their vested interest property. And then there also is usually language that talks about if you do file a claim that they are entitled to have their name on the check. So therefore they have to sign off on the check and they'll decide at that point in time what they want to do with the check. So what'll normally happen is a check comes in, you'll usually get a check. It'll have your name and the mortgage company's name on it. You'll go to your bank, whoever the bank who has the mortgage, and then you'll talk to them about whatever procedures are. Some of them have rules where if the check is under $40,000 or $30,000, the mortgage company will just sign their name and they'll give you back the check. And now you can deposit it and get the work done as you see fit. So a lot of the banks will have a threshold and say anything under that, we're just going to sign it. But then if it's over that, or if it's a bank that's just saying, hey, every check we're going to process this way, X way, then this is what they'll usually take the check. They'll have you sign it and say, you need to sign it because we're the mortgage company. We're going to hold the money. So let's say it's $100,000. They hold it. And then they'll tell you, we're holding it. We will pay it out in draws. Once you give us the contractor's contract and we see what the scope of work is going to be, a lot of times they'll ask you for the insurance company's scope of work. So they technically start to become your GC, your general contractor. Kind of what they start to become, like this consultant on the job. They also say a lot of times that they will pay a down payment to the contractor and then they'll pay, this amount after, the 1/4 of the job is done, this amount when half the job is done, this amount before the final inspection, and this amount after the inspection. And then a lot of times they'll send a rep to your property to actually go see the property to make sure it had been done before they make the final payment to the contractor. It is very difficult. It is so time consuming. And that is a whole issue people have dealing with their mortgage companies. And we tell them, unfortunately, these are all agreements you've made with the mortgage company. That's why they most time are behaving that way. But I will say that as frustrating as it sounds, there's been a lot of times mortgage companies and that behavior has saved property owners who may get taken advantage of by a contractor by giving them all the money up front because they didn't know any better. So there has been times where a mortgage company withholding that money and having that draw procedure has actually saved the insured in the end. So it's kind of like, a double-edged sword there.
Yeah. Yeah, that's peculiar because you think, oh, just give it to me and I'll do whatever I got to do. Mm-hmm. But I guess if you're dealing with a $100,000 reno, it's a much bigger situation.
Yeah. Yeah.
Okay. That's pretty intense because I don't think most people know that that's where that.
Well, you would never know until you've been through an insurance claim. It's not something you would have ever known, but you get some people who are getting a check for $250,000 for damage. And unfortunately, even the most honest person who gets a $250,000 check, if it was given to them, depending on what's happening in their life, everything can be falling apart. And they're just like, I'm about to lose, our cars and I'm just going to use the money for that. And I'm not going to put it towards the house. So that's really the reason why the mortgage company is like, listen, even though we trust our people, let's make sure that we're keeping them on the straight and narrow here, because it is a significant amount of money that comes out of some of these claims sometimes that is really for the remodel, the reconstruction of the home.
Yeah. And to wrap that thought up, let's say you get $100,000. Let's say your mortgage is $200,000. You got a $100,000 claim. They're holding it. And then you decide World War III, you hate the marriage, you're leaving. I don't want this house anymore. Too many bad memories. Kid died in the house. Something terrible, right? You just say, forget it. I'm done. Would they just use those funds as part of the payoff?
So it's interesting how they'll do it, because every mortgage company is a little bit different, and it all depends on what agent you talk to that day, because ideally that money is actually not specifically to go towards the mortgage as much as it go to reconstruct the house. But I have seen times where you can request that the money that's left in there, that whatever's not used, goes to pay off the mortgage. And there's times the insurance company will say yes, but there are times the insurance company says, whoa, wait, what's the status of the property? Did you actually repair it? And this is money that was saved. Like the insurance company gave you $100,000, you hired your contractor friend, and now you only spent $60,000. And so if the mortgage company says, okay, well, you actually did repair the property and we inspected it, we'll take that excess money and we'll apply it. Or the insurance company might say, listen, there's $40,000 here, but did you do all the work? And if your answer is no, I didn't, the insurance company could potentially hire and decide they have to bring in their own contractor, or could potentially say, well, now you're in violation of your agreement with us and the mortgage company. We're demanding that you hire somebody to finish the scope of work. That they can also do that. So it's not so easy black and white to go, yes, they can just apply it to your mortgage. It's always great to ask for that, but they can come back and say, actually, this money was supposed to go to repair the house. And therefore now we're actually taking a financial loss on the home because you have not actually repaired the property. And that's technically in violation of your mortgage.
Okay, perfect. Well, but that's if you don't get a payoff. Oh,
yeah.
perfect. Okay, got it.
Yeah.
So out of curiosity, let's say somebody is, maybe there isn't a mortgage necessarily. Well, maybe there is. And they have an open claim. And they, they're from the Midwest. They loved being on Fort Myers Beach. They love being in Jacksonville, whatever. The place is either leveled or it had so much water in it, they can't even turn on the power. It's just done. And they want to walk away. But there's an open claim. How does that work without being too technical?
So if you have an open claim and you decided that you're going to sell the property, you can do that. So there's a couple of things that we always say you got to be really careful for, and why it's great to work with an agent in real estate that understands what happens after a disaster. It is really, really important, because there's two different things that can happen with the claim. You can either, as the buyer, keep the claim, sell the property. Now you still have this insurance claim that keeps on going, and you can potentially just take the money whenever it finally pays out, and you can do whatever you want with that money. So you get a nice little, chunk of change later on. Or you can take the insurance claim and you can assign it to the buyer. So now the buyer gets the insurance claim, and now they're entitled to the money from that. So that's always a negotiation that a great agent who understands that can use it as a negotiation tool. So depending on what works, you keep in the claim, or are you assigning it? Those are the two options. The other part that's so important is that you're really careful in those closing documents, those selling documents, that the damage, or that there was damage, is somewhere there articulated. So let's say you're going to keep the insurance claim, but then when you go to sell the property, you say that there's no damage on the property at all. The insurance company can use that against you later on. And that happens a lot, right? Because you want to sell it. So sometimes do, a haphazard inspection, and they won't tell them about the insurance claim. What? And so they'll say there's nothing damaged. Oh my gosh. Let me tell you, in litigation, when they sold the property, the very first thing they subpoena is from the agent, the real estate agent. They subpoena all the closing documents to see any damage disclosure. Yeah.
You get your ass. Yeah. People, if you're an agent and if you're listening to this, don't do such a stupid thing. There's clue reports. There's evidence. It's so easy. And then you get stuck, not only potentially fraud, misrepresentation, but also dirtbaggery. Don't do it.
Dirtbaggery. Yeah, exactly. Yeah.
I'm sorry. I interrupted. I apologize.
No, absolutely. No, these are great. There's a great point. It's just it's the more you know at the end of the day. Like, that's what's so important, is that knowledge is truly power. In order to help people, you've got to, I'm as an attorney who litigates, see like the problems that come forward, and letting people know them so we can try to stop those is priceless to me.
How do
Like,
you
this
go
is why
about
this is so important.
when so let's say I'm representing either the buyer or the seller, really. How do I make sure that inside of the contract the damage is specifically noted so that whomever maintains the claim will be able to still go forward? Because I would assume it's a little bit harder to argue it when you either no longer own the house or you were no longer the original insured.
Yes. Yep. I less is more. The less specific you can be, the better. I mean, it's just making sure that the best thing is there's nothing that says that there isn't damage, right? We'd start with that and be like, if you can stay away from anything saying, hey, there's no damage, that's better. If it is discussed in any of the documents, just saying, the roof has damage and there's interior damage, that's enough. Just telling them there's damage. I think less is way more. Because you may, at the time you're selling it, like, that's why we also say, hey, you should also, if you're going to sell the property, get an attorney involved, right? Because our job while you're potentially going through the selling it, is we make sure you have everything documented right. We see what those final disclosures look like. We definitely help with that. We have a lot of people right now, especially if you're saying for Myers Beach, any of those areas, we're just saying, hey, I'm going to sell it, which is understandable. A lot of and so, especially if you went through Irma and now you went through Ian. But the best part is like, they're asking us these questions and we're making sure we're protecting them then. So we're saying, you want to make sure you have the right person representing you so they can come out too and do a full inspection. So if the insurance company just paid for a couple of just a little area of shingles, but you really needed a new roof, at the end of the day, if you put on that disclosure that all it was the couple of shingles because the insurance company said it, and we get involved and we're saying it's a whole roof, it also makes it difficult. So less is definitely more. The little piece, not to make it confusing, but the only real difference is if you no longer own the property and you're still keeping the insurance claim, you're not entitled to the depreciation or law and ordinance. So those are two areas of your policy, depreciation and law and ordinance, that require that you incur that cost first in order to reimburse you. So it's not, I always tell most of the time, tell the insureds, it's not enough to stop you from selling. If you decided to sell, it's just good to know we can give you an idea of what that number looks like. When we start running the numbers, we go, look, this is what you're probably going to make after in the insurance claim. And this is what you would potentially be losing if you sold it before. It's usually about, 20% sometimes of the number. It's not usually worth it when an insured's doing the math. They'll usually say, I'm still going to sell the property, but we do definitely go over those numbers, which is why it's important to work with, the right agent, but also potentially the right attorney who understands that process to make sure you're protected.
Yeah, so what I'm taking away from that, which is so valuable, and I don't know if you caught this, but the percentage, people think, oh, the whole claim is X, or here's the value. It always
Yeah.
goes down to the percentage. And having somebody who's
Yeah.
been in settlement and in the courtroom will know what that looks like is valuable to you. So just because people want something and there's a number that could be there,
Yeah.
tried and true is where you want to end up. Also, that was a really good nugget about that you actually have to incur those two costs versus
Yep.
the other. So if you still own the house, then those are still at play. But if you don't, let's say the buyer is the one who inherited that claim.
Yeah.
Is the buyer still entitled to the law and order? Law and ordinance?
Yes. So law and ordinance. Yeah. If they incur it, then yep. Because what happens is when they get assigned the claim, they actually stand in the shoes as if they were the original property owner. So whatever they do is just like the original property owner. So if they go and they get the claim assigned to them and now they move into the house and then they do all the rest of the work, they will be entitled to potentially that full amount.
Got it. That is gold right there, folks. That is gold. So important. It's such a nuance that I don't think is very easy to find on the interwebs if that's what you're trying to search this kind of thing. So good. All right. Awesome. Thank you for that. Next. And this is winded. We're almost on an hour. She's still firing up. And I'm telling you, folks, this is the kind of person that you need. Her support staff is super strong to be able to catch all of what she's working in, but it's that brain that's going to get you what you need so that it's just at the end. Sometimes people feel like, oh, attorneys, they're greedy, they this, they that. People think that same thing about realtors too. But what you don't understand is how much money you're going to save yourself. And you have to be greedy up front. I hate to say that because that's not my nature, but you have to be greedy up front because the insurance company in the end is going to always settle on a percentage. And that's why you have to go for as much as possible. And you're not a bad person, especially you're from Ohio, the Midwest, and it's kindness is your thing. I get it. When you're dealing with a snake insurance company, you absolutely have to be aggressive first because they're going to negotiate you down later. Would you say that's about accurate?
Yeah, it's very accurate.
Sad, but yeah. Okay, cool. We kind of covered this before. Super short. Who should somebody who has been affected by a disaster trust?
Who should they trust? So I know that's usually where they become really frantic afterwards, because it starts with them trusting their insurance company. And then when they defy their trust, they become so raw that they don't coming to them, from roofers to contractors to mold mitigation companies to water dry out companies. They're all coming their way. And they are really feeling like they've been let down already and defeated. And they're like, now what do I do? And I always kind of say, listen, I know it's hard to just trust your instincts and say, hey, this feels right, but it's also do your research. Like if a contractor comes, I always say, Google them, start by Googling them. If you know how to look them up at the Florida license search engine from the Department of Business and Professional Relations, in order to see if they have a license, then at least Google their name and make sure they're an actual company, right? Make sure a website comes up is where it should kind of start. Because we've got issues when they come to us and they never even Google them. And I'm like, this company doesn't even exist. And that happens a lot. And then also, as obviously I'm an attorney, attorneys are supposed to be an area of trust for you. Like that when all else fails, you can at least go to them because they represent you solely and nobody else. So in regards to that situation that you're in, right? They can't represent the other side too. So that's who you really can trust to be on your side, to at least guide you in the right direction. And so that's kind of where I say, listen, do some research first, but also not just self-promoting because we're attorneys. What it was, right? We were counselors of the law. In order for you to feel like you can give us information, we're not going to repeat it, and we're going to give you the best advice possible for you to protect your rights.
Perfect. Tell me what the deal is with people talking about assigning over benefits to roofers. We talked in another video about the idea of assigning the benefits to a buyer or retaining that, but what does that mean? There's be careful. They just want the benefits for themselves. How does that play out?
I know. So the concept is called an assignment of benefits. AOB is what you'll hear about it. And what that is that it is when an insured has an insurance claim. And what they do is I always think that your insurance rights are like a pie. So think of a pie. It's all your rights are an entire pie. You can actually section out your rights depending on what area of damage you have. So damage, almost every company you can hire to fix your property, they can all be assigned a portion of your rights. So if you hire a roofer, they can be assigned the portion of your claim only for the roof. If you hire a mold mitigation company, they can be assigned a portion of your claim to do the mitigation. The reason why you would do this historically, back in the day, and people did it all the time, people are less doing it now because they're afraid of it. But the way that it worked that way is because if you signed your rights to that company, then more than likely what that company would do is they would actually repair your property, not charge you anything usually besides your deductible, even though they hadn't got enough money from the insurance company. You've assigned that right to them, which means now that company can stand in the shoes of you. So you could file a lawsuit, so could that company. That company gets to file a lawsuit for the work they did or the work they intend in order to fight the insurance company to make sure that you fully get paid. So it really was kind of people were sometimes assigning their entire claim, entire remodel to a general a general contractor who was going to do it all, who's going to remediate the house, who was going to actually hire the mold company to mold inspect and then to remediate and then to rebuild the property and do the roof and the interior and the exterior. So they were going to do everything. So you'd assign your claim, would then fight with the insurance company. That's the other thing. It gives them the right now to fight with the insurance company. And the way the law is in Florida, if the contractor wasn't actually the insured, which they're not because they're the contractor you hire, they were not allowed to call the insurance company and fight back and forth with them. So it used to give them the right to now fight with the insurance company. And then ultimately it gives them the right to file a lawsuit. They filed the lawsuit in their name, but it has a that it's on behalf from an assignment of benefits of the actual named insured. So the benefit was, if someone's willing to do work on your house and you need it done and the insurance company hasn't paid you enough and you're desperate, you would assign an assignment of benefits if that company was telling you that they're going to do it today and then fight the insurance company later. The reason why the company, yes, yeah, your roof's raining. The company really needed that assignment of benefits because that's what entitled and insured them that they're going to get paid. Because here's what would sometimes happen. If the roofing company goes, hey, I know you're desperate, we're going to put the roof on, they don't get an assignment of benefits. Now the insured goes, well, I've got a roof on. I don't want to fight the insurance company. Mr. Roofer, it's you who's owed money. I'm done fighting the insurance company. I'm exhausted. And the roofer goes, well, I can't fight him because I'm the one owed money. I don't have the right to fight the insurance company for a contractor. It's actually considered a felony for them to negotiate with the insurance company. So it all makes sense when it's being used correctly, when it's very clear on the scope of what they're doing, right? They've provided you an estimate so you know how much it's going to be. Then you assign the rights to them, and they're either going to do the work or they're going to take on the insurance company for you and then do the work potentially later on. So there's reasons why people will sign an assignment of benefits. What has happened, unfortunately, is that the insurance company doesn't like that. And here's why. They tried to make it seem like the reason why they didn't like it was because some contractors would get an assignment of benefits and then wouldn't keep the insured, wouldn't keep in touch with them on what the process was and all this other stuff. Some contractors stole money. It happens anywhere. They acted like that was the reason, and that they wanted to change the laws of assignment of benefits, and they wanted to create advertisements against assignment of benefits. And they're sending emails to insured saying, don't sign an assignment of benefits. You've heard commercials about it. And the real reason why, and this is, I have no problem making it very clear, is because if you think about it, the insurance companies benefited most from the desperation that the insureds had on wanting to get their home repaired in some way. So if right now you haven't been paid enough, and 6 months from now you're still living outside your house, and you need $100,000 and the insurance company has paid you 20, and you're desperate for it. You're like, I have no more money to pay out of pocket. I'm out of my loss of use, additional living expenses, because that can cap out. I'm out of that. Now what do I do? And the insurance company comes back to you and says, listen, I know you want $100,000. You 45 or 40, and then we'll close this whole thing out. Well, if you're desperate and you're like, I know I needed all this work done, a lot of times they're willing to take the lower amount and say, well, I guess I just won't get this done. I guess I just won't get this done. I guess I'll wait till I get my bonus, or I'll cash in my 401k or my retirement, and I'll do the rest of it later. So a lot of times that's what, because they're desperate. Well, the assignment of benefits concept allowed a bigger company to come in and do the work and then wait to get paid till later. And that company could front those expenses and they didn't become desperate. So that's the real reason why the insurance companies have all this big rhetoric and just an entire just smear campaign against assignment of benefits. They are not bad. We always tell people we'll review them for free. We'll make sure that they're in accordance with the law, but don't just get scared away from them because you've heard it. if you're desperate for work to be done and they're willing to do the work and not have you pay them right then, and all they want is an assignment of benefits of it, and they've told you how much it costs and you're okay with that, you can do the assignment of benefits. You should want to do the assignment of benefits. Now, right now, people are really scared. 3 months from now, when the insurance company has not paid them enough and they're fighting with them, and their house it's raining in their house as they speak, it's leaking every single time, they smell mold, a high smell of mold, they're going to look again at assignment benefits and see there's a potential value of it. So it's just being really careful. And those are things that when you're represented by us, we help you with those. We tell you when we think it is a good time to potentially sign an assignment of benefits and when it's not. We work really closely with a air quality assessment company, and that company always does assignment of benefits, and that's beautiful. They will come out, they will assess your property. It's AQA, that's the name of the company. They will assess your property, they'll do a mold test, and they will always charge it to the insurance company. They will go after the insurance company. If the insurance company does not pay, they will not come back to you. So it's beautiful, right? And so that's where an assignment of benefits is being used accurately. And so as long as it's being used right, it can be really helpful.
It's interesting because you're right. There's been a campaign. I mean, I believed it. Like, I didn't know why.
Didn't know why, but it's because they said it. They were like, you don't want to lose your benefits. You don't want to lose your benefits. It's not losing your benefits. It's transferring a benefit to somebody else so they can fight while you now have gotten everything you need. Like that is, it's literally what it is. It's like being hungry, like you're feeling starving and someone comes to you and says, listen, I will give you food, take away your hunger, and I'll take on that hunger myself. And then I'll go figure out how to get food. You're going to do it. It makes sense. You should 100%. Do it. The insurance company wants you to stay starving. So then they can decide what pennies and what crumbs they can give you when they can't do that with a big construction company.
In Florida, how do attorneys get paid as related to doing hurricane lawsuits, things like this? How does that work?
Yes. So the way that like our firm gets paid is a contingency. So you don't pay anything up front. You only pay if the law firm gets you additional money. And the way that it usually works is there's a percentage, right? So we usually say, hey, if we get you any additional money, you're going to pay us X percentage of that money. But if we have to file a lawsuit, so we work that pre-litigation, and then we file a lawsuit if we cannot come to an agreement that we all are on the same page and agree to. If not, then we file a lawsuit. In the state of Florida, if you sue your insurance company and then they have to pay you even $1, they have to pay towards your reasonable attorney's fees. So what that means is, let's just say that the percentage fee was 15% or 20% or something. Let's say 15%. And let's say that your damages were $100,000. What you would normally owe the law firm at 15% would be $15,000 if they got you $100,000, right? And I can tell you, that's good. It's good. I'm like, it's a great place to be in. If it's getting you money you wouldn't have gotten. Now, if we have to file a lawsuit and then we get you to where we're able to settle it in the lawsuit, and the insurance company's like, okay, we're going to pay the $100,000, and then additional, they have to pay towards your attorney's fees. So let's say they believe at that point in time, the attorney's fees are $15,000. Like that's how much work has been put into the file by hourly. Then they'll pay $100,000 plus the $15,000, and you're potentially paying not a single dollar out of your money. So that percentage, that 15% that you were going to pay, now you potentially don't have to pay any of it. So the insurance company's paying it. So it's like off only, almost most of the time. So there is a benefit for filing a lawsuit, especially in Florida. It is one of the only states that has this strong statutory attorney's fees. And it's based on the fact that that's so common for the insurance companies to behave in a way that is that's unreasonable most of the time, unreasonable how they behave. And so that's why there's a statute that says, hey, if the insured has to sue you and they recover money, because that fact is that you wrongfully didn't pay it to them, they get an entitlement to attorney's fees.
Boom. So
yes,
recap, that very important thing is if they can settle it for more than what you've already advanced before filing suit, then they just make a percentage that you pay. They file suit and you win, whatever that amount is, then it's paid by the insurance company. So I love the idea of filing the suit early. I was not one who believed in lawsuits
Yeah.
until it happened to me. And then I'm like,
Yes.
go. And I just happen
Yes.
to have the worst. I mean, actually, I don't care.
Absolutely.
Universal Property and Casualty. I'll end every single conversation with them as the worst insurance company in the world. All right.
I understand. I understand. And then I'll tell you another question that usually comes up a lot is the difference between a public adjuster and an attorney. Yes. So here's how it works. Public adjusters are licensed by the state, and what they're allowed to do is they're allowed to work specifically for an insured. They come in, they will charge you a percentage insurance company. They write an estimate, they fight back and forth with the insurance company, and they try to come to an agreement. And usually they charge between 10 and 20%. If it's a hurricane, they can't charge more than 10% in Florida. So they charge you 10% to get additional money. Now, if they can't get you any more money, then they still usually have to send it to a law firm, and you still have to pay them that 10%, even if the law firm's the one who eventually gets the money. That is important to understand. You're paying the public adjuster for the work they already did. Even though, let's say that the insurance company doesn't give you any money and it has to go to a law firm still, you're still paying the public adjuster that 10% because they wrote your estimate and they tried to work with the insurance company. They packaged it, got it to the law firm, and a lot of times are a consultant for the law firm during the process through litigation. So a lawyer, there are law firms, like one of them's like our law firm, is we take claims for adjusters all the time, but we also have clients who come to us, especially recurring clients who come to us directly, and our law firm can do the adjusting part of it, which is what we were talking about before, where we can come in, we write the estimate, we work with the insurance company, and then if we can't settle, we file a lawsuit all within the same company. So it's kind of either way. A lot of people want to go to a public adjuster because they're like, I don't want to see a lawyer, I don't want to file a lawsuit, and that's understandable. There are people that way. So you have to be prepared the fact you're going to pay that percentage, and then depending on the situation with the lawyer, sometimes they'll do a reduced percentage because you already have the public adjuster percentage there. That's always up to the public adjuster and the attorney and the client. Or you can go to a law firm that's like ourselves. If you say, hey, I'm okay with there being a lawyer, I want a lawyer involved right away. And you can go that route. So it's kind of just, a lot of people just choose one way. And as long as you're using either one or both, you are in good hands. Like, that is a good place to be in when dealing with the insurance companies after a devastating loss like this. And our hearts just go out to everyone who's been impacted by Hurricane Ian. We specialize in hurricanes, so this is what we do all over the country. And so we understand that plight afterwards and what it feels like, and the desperation and the devastation. And we Irma down here, which didn't even hold a candle to that. So we've had a presence down here in the south area, the southwest area. So we just adore all the people here. And I mean, Sanibel Island has my heart. I mean, it is so devastating. And I've been there when I was younger. And so to see it the way that it is now, it's heartbreaking. So we just hope that we're able to help as many people as we can to put everything together to their life, so we can get these towns kind of up, back and running, so that small town mentality can be maintained.
Yeah. And I think people on the outside don't get the grief process that you go through, because in the beginning you have hope, you believe that somebody was there to help you insurance wise, or FEMA or whatever. And then you're in somebody's basement, a friend, a family member, then that relationship's strained, then the insurance isn't working. And it really is, you go through stages of grief. And quite frankly, by hiring other people to handle some of this for you, it really enables you to take an emotional step away. And I think that the hardest part, when I was watching some of my fellow realtors who had all been really in the thick of it, some of them still don't have roofs now, but like they were in the process of themselves picking up the pieces, and they just didn't know how to advise their clients because they didn't want to sound like car salesmen. At some point, you've got to be able to help figure out what a next step is, but when you're in your own moment, you don't necessarily know how to do that. So there's a whole psychology to how this whole thing works, and I think it's important to have people that can really help navigate it, both because they're their experience, but also the expertise and where you got to go. So finally, let's wrap this up.
Yes.
One of these questions I thought was pretty helpful. Actually, I got two, but I really like this one. What do we do about sheds, seawalls, and trees? Because those are all different animals.
Yes, it's because sheds, seawalls, and trees are usually going to be the three biggest areas, especially right now in our area right now. And they usually have some of them, some policies have exclusions, so they're not covered. So that's what you got to look for. And then most of the policies have limitations on them. That's why it's so important that you understand what's in your policy, or you look to like an attorney to review it, to give you that free advice and say, hey, I just want to know if this is covered in my policy or not. Like our law firm will do that, because you could potentially have, sometimes there's $500 for tree removal. And if anyone has had to look at their tree removal, like invoices or even estimate, thousands of dollars. It can be $20,000 on some of these homes right now. And so a lot of them have exclusions for their seawalls. Their seawalls are just absolutely not covered. And sheds are usually considered other structures in your policy. So that's usually your category B. It'll be other structures is going to be any type of structure that's set apart from the main dwelling, set apart and not connected. It can be connected usually by electricity potentially, but if it's connected by like a fence or it's attached to the house, it's not considered other structure. So a shed will usually be the other structure, and you have an amount limitation for that. Most people, as they're reading now, they're realizing they didn't have enough coverage in other structures to cover it. So that's what I'm talking about, are so important that you understand before you incur a cost. Before you have someone come and remove all the trees and go, hey, I'm going to go after your insurance company, anything left over, I'm going to come to you. Or, hey, I'm going to fix your seawall. Before you incur that cost, you need to make sure that you've got the coverage for it, because you don't want to find yourself in a financial situation where you have to now come out of your savings or take a loan out. That will happen. Take a loan out to cover that cost.
110%. If you have one of those free community resource people that's out chopping trees for free, which I've done a lot,
yes,
let them do it, because you ain't gonna make that money back.
Absolutely.
In non-hurricane situations, trees fall all the time, right?
Yep.
Sir, the 100-year-old question: my tree falls on my neighbor's house. Whose insurance responds?
So the tree that falls on your neighbor's house, as long as it's not due to the negligence of you, your neighbor's insurance company has to cover that. That's who covers any damage that happens on their property, is going to be that insurance company of that person's property.
And there's no way to sugarcoat that. That's how we're going to end that part of that video. That's it on the trees.
That's it.
100 times a day that question comes up. So, all right, Candice, thanks for wrapping that up. I really appreciate all your work setting down some time for us. Super quick, how do they get a hold of you if they have more questions?
So if you want to reach out, listen, like I said before, all of our consultations are free. Just reach out and ask us questions. You can call us at 727-733-9438. You can go to our website at myhurricanelaw.com, all one word, or you can email us at office@Colucci, COLCCI, lawgroup.com, all one word.
Perfect. Again, folks, we believe in leading with an open hand, open heart. If you have questions and we're not necessarily a fit for you, but we can still help you find some of your answers, feel free to reach out. James Derek Keller Williams, thank you again. Hope you're having a great day.